I do want to thank NSSEO for always partnering with us on these events. They've been partners with us from the beginning, and they help us provide the continuing ed credits for our professionals. And Palatine Township, which supports educational outreach with community funding. We absolutely couldn't do all the stuff we do at the price we do it, or free, in the case of these events, without their support. So I want to thank them. So let's get to speaking today. Our speaker today is Cristina Headley. Cristina is a staff attorney at Equip for Equality, where she provides advice and advocacy assistance to people with disabilities on cases involving guardianship and the rights of those receiving services in facilities. Her casework focuses primarily on preventing abuse, neglect, and financial exploitation, advocating that people live in the most integrated setting, and supporting the decisions of people with disabilities. Cristina also provides trainings on these issues, which is why she's here today. Cristina's presentation today will focus on guardianship in Illinois, regarding where it's appropriate, what alternatives might be appropriate, the rights a person under guardianship retains, and the responsibilities of a guardian. So please help me welcome Cristina Headley.
Good morning. Thank you very much for having me today. We're always excited to hear when a parent group is really interested in learning more about this area. So as you know, I'm a staff attorney at Equip for Equality. And first I want to tell you a little bit about our organization. We are the state protection and advocacy organization for people with disability in Illinois. We serve the whole state. And the protection and advocacy network is a network that was created by the federal government in 1975 to have an agency in every state serve as legal advocates for people with disabilities. So we provide a variety of services in different areas. So we provide individuals with legal advocacy in terms of anywhere from advocating on their behalf with a service provider, with the state that's providing some sort of services to them, with an employer, with the school district. And we also, and that goes from advocacy to, you know, if it involves representing them in an administrative case or in court. We also provide individuals with self-advocacy assistance and advising them what their rights are in a particular situation and what they should do. We also have a public policy unit that advocates for changes in the law, and we provide training and education like I'm here doing today. Some of the areas that we provide assistance in are special education. We have a special education clinic. We also have an employment rights helpline, and we also provide services in a few other areas like representing individuals in guardianship cases, also dealing with Medicaid waiver issues and rights violations in facilities and different home settings. And we also have an abuse neglect unit that does more systemic investigations of facilities in different housing situations as well. I'm happy to take questions if you have them throughout my presentation. Please keep in mind that I can't answer specific questions about your situation in a group setting, but I'm happy to answer questions throughout. I also ask that you complete the evaluation that I have. It's a very simple form that has the smiley faces or frowny faces on it. So here's a little roadmap of what we're going to be discussing here today. And so guardianship is only obtained through a court process. And the results of guardianship are a great infringement on an individual's rights. And so, you know, there are only a few situations in which the government can restrict an individual's rights as much as in guardianship. For instance, in a criminal case or in a mental health case where you're forcing someone to take medication or to be in a hospital to receive treatment. So it's important to understand what guardianship is and what some alternatives might be. And I understand that, your organization is interested in, is focused on helping families and individuals transition into adulthood. And so I think this is a really important topic, especially because I think generally we hear that in the past, the advice has generally been given to families like right when an individual turns 18, you have to get guardianship if your child has a disability. And we think it's a really more of a nuanced and individual approach, and people don't really know what they're getting into. So I'm here today to explain what guardianship is, as well as some alternatives, explain to you the process of obtaining guardianship, and then when you do obtain guardianship, what rights the individual still has, and the responsibilities of what a guardian have as well. So before we dive into these areas, I just want to take a step back and recognize what we're talking about today. We're talking about the decision-making process and who has the authority to make an individual's decision. And so decision-making involves all these components: understanding what the issue is, gathering information, considering the options and the consequences, exercising choice, communicating and implementing that choice, and evaluating what the results are, and figuring out, whether you made the right choice and whether if it comes up again, you would do the same thing or do something else. This is something everyone does on a daily basis. And so the ability to make decisions is really on a continuum. It's some individuals, one day they might be, more capable of making a decision than others, or, certain types of decisions they might have more difficulty than others. So decision making is really understood on a continuum. And some examples of decisions we're kind of going to be talking about today in these different areas are: where will I live? What activities do I want to do? What relationships do I want to build? How will my daily needs be met? Where or whether I will work? So in order to help determine, whether guardianship or an alternative is appropriate, we're looking into whether an individual has the capacity to make decisions. And it's not really whether an individual has a capacity to make a good decision, because what might be a good decision, for some person, you think for the person, or, might necessarily be a good decision for someone else. So there's no standard for whether a decision is good. But, a poor decision might not look at all the elements of the decision-making process. So it might only look at the immediate benefits, or oversimplify the issue, or be influenced by another individual that might not have the individual's best interest at heart, or influenced by emotion. So a better decision looks at, different perspectives, considers both short-term goals and long-term goals, what the potential outcomes might be, and allows for different types of input, and takes advantage of all the tools that individual has available to them. And so, capacity to make a decision is different from capacity to carry out a particular task. Like an individual might have the capacity to consent to surgery, but not be able to perform that surgery. So what we're talking here today is the capacity to make a decision. So now let's dive into alternatives to guardianship. So because guardianship is such an intrusive measure on an individual's rights, we recommend that before family members or an agency goes into court to get guardianship, they should really consider whether guardianship is truly necessary, or whether there might be an alternative that will meet the individual's needs without unnecessarily depriving them of their rights. Because guardianship is not supposed to be necessary when the individual has the supports in place to help them with decision making. So there are types of alternatives that sort of mirror some of the assistance that guardianship provides. And one of the main ones is powers of attorney. And so powers of attorney is a document that the individual completes, and they must be created when an individual has capacity to sign a document and to make that decision that they want to designate someone else to be able to make their decisions, either with regard to financial decisions or with healthcare decisions. And in this sense, when you're determining capacity, it's really a doctor that determines whether that person has the capacity to sign that document. If there's some question about whether the person has capacity, whether there might be some question, it's good to consult a doctor on that. So there are for each property and healthcare, there are two types of powers of attorney. So one type is the person says, I am still going to make all my decisions right now, but if something happens to me in the future where I have a major health issue, or I decline and I don't have the capacity to make decisions, I want this person to make my decisions. But even if they have the first option in place where the person starts making, or I'm sorry which one I said first, but if they have the option in place where they say, I want this person to start making my decisions right now, the power of attorney does still have to follow what the individual wants, and if it's with, if you say, I want the power of attorney with regard to finances to also have access to my bank account, for instance. Oh, the last one is just the last measure here is a mental health directive. And this is a statement that an individual would prepare to say that they want another individual to make their mental health decisions for them if they become not capable, and a doctor would determine that they were no longer capable of doing so. And in this document, they can consent to receiving ECT treatment in the future, psychotropic medication, and inpatient treatment for up to 17 days. The next measure is the delegation of right to make educational decisions. So this is a measure that, a form that a student might sign once they turn 18, that designates another adult, oftentimes a parent, to give consent to them that they are going to make their educational decisions. It lasts for 1 year. It can be, if they're still in that program, they can, sign another one after that year. The student, though, still has a right to be present at any IEP meetings and participate in that meeting. Another measure that I mentioned is representative payeeship. So the Social Security Administration has a process whereby if they determine that a person is unable to manage their funds, and they normally do that with the support of a doctor, that they designate someone else to receive and manage those funds for them. The rep payee has to report to the Social Security Administration, and they can only spend those funds for the individual, not for themselves. Another model that is being talked about more these days is called supported decision making. And it is an alternative model whereby individuals retain their rights and decision making capacity with the supports of the individuals or services that they have, depending on what their needs are. So if they need help like understanding a question when issues come up, if they need help investigating different solutions, raising pros and cons, or communicating their own choices, it's a plan that the individual and the people or services that they have that support them come together and put together a plan for whatever the individual's needs are and what different areas, different types of decisions, whether it's housing, services, employment, and then what happens in the decision-making process and who is going to be there to help that person. It's a different model than guardianship or the other alternatives that we discussed, where another person is the substitute decision maker. Here, it's still the person who is making their decisions. They just are kind of formally recognizing, like we all do, that they're utilizing the supports that they have to make those decisions. There has been scientific evidence that this model leads to better health and long-term life outcomes because the individual retains their independence, their ability to try new things, discover new capabilities, learn from their mistakes, like we all do, and be more actively involved in their lives and their health outcomes. And that ultimately leads to more independence.
Is this supported decision-making a document?
So I'm about to get there. It has not been formalized in Illinois law yet. There is pending legislation in some states. In a growing number of states it has, and so they have formalized it with documents. So yeah, I think there are recommended forms by some of the agencies that have supported decision making, like the American Bar Association, the U.S. Department of Education, and the Health and Human Services. There are some models for these forms out there to how to put this together. There are laws, and in some states too, it's a document that everyone fills out. And in some states, it is filed with the court, so it is. It is formalized that way. But I'm not sure that that's the case in every state that it's been passed. If you have a child with, an intellectual disability or, that has an IEP in school, it's kind of, it might mirror something like that, or a personal plan with a SILA provider or a day program provider. It kind of I think it kind of mirrors some of that planning where I know especially with, SILA providers and day program providers, the focus is really on person-centered planning and what the individual's goals are in that sense and how to help them accomplish those goals. And so this is just kind of a different issue, decision making, but formalizing the decision-making process in that sense. For that is really sitting down with your child or family member and saying kind of, this is the plan. We're here to help you. Maybe we're concerned about that situation where you might try to go buy a car or you might, try to enter into a contract. And we want to help you to make sure that you don't get taken advantage of, okay? And we want to prepare you to make those decisions on your own. So if someone, comes up to you and says that, these might be some things to look out for, or come to me and we can make that decision together. You can't force anyone to go into supported decision making or to make a power of attorney. Those are all things that the individual decides. But I would recommend, trying to talk to the individual about it and talking to their healthcare providers. Those are, that's really what, that's who you need to consult. And also really thinking, is, the threats and concerns that you might be afraid of, whether jumping into guardianship right away is really a good idea, whether, trying out supported decision making or whatever your own plan is first before, jumping into guardianship, or whether the concerns that you have are really, in the short term, going to be realized. Like if they're still going to be in school for a number of years and you can still, participate in those processes, whether, they're going to be, they're willing to participate in the programs that you've found for them, whether they're really going to be out on their own and encounter, those things. So it's really an individual, exploration, so. Any other questions before we talk about guardianship? All right. Okay, so guardianship, people only obtain a guardian by going into court, and only a judge can appoint a guardian. So sometimes I still do hear people get the terminology confused between a guardian or a power of attorney. Some people call themselves both. But a guardian, an individual is only appointed a guardian if they've gone into court, if they've asked the court to appoint a guardian and the court has done so and issued an order saying this person is the guardian and they have these powers, okay? And so the court will specifically say what the individual has the authority to do on behalf of this person. And, while that case is still, until the court terminates the guardianship and closes the case, that guardianship is still active. I did have a case, believe it or not, where someone was saying their mother was, using a court order with the nursing home to say that they had, that she was the guardian. And she insisted that, no, the case had been closed. And the nursing home, though, was still following the mother's decisions. And sure enough, I called up the clerk's office and got a copy of the order that said the case was closed and had to had to show the nursing home that no, it wasn't an active guardianship. Okay, so in order to show the court, in order to get a guardian, it's not just appropriate to get a guardian when a person has a disability, okay? So just because an individual has a disability does not mean they are appropriate to have a guardian, okay? You have to show that because of that disability, they are unable to make responsible decisions and understand those decisions. And so this is done through the recommendation of a licensed doctor, okay? And so, you know, guardianship, because I've talked about how guardianship, you know, results in a great infringement on individuals' rights, the law, Illinois law regarding guardianship, you know, really tries to stress that it should only be put in place if it is absolutely necessary. So, you know, if an individual lacks the capacity to understand or make responsible decisions, and only to promote their well-being, to protect them from neglect, exploitation, or abuse, encourage the development of maximum self-reliance and independence, and only to the extent that is actually necessary, you know, by the individual's actual limitations and circumstances. So in that sense, kind of like what we were talking about with supportive decision making, you know, if an individual has, you know, lacks some capacity to make their decisions, but they have the services and supports in place to help them make those decisions, then they don't really need a guardian. So what we argue sometimes is that, you know, if an individual lives in a CILA, attends a day program, the CILA provider is their representative payee, and they are able to, you know, to some extent participate in their decisions, and they are not at risk of having, you know, being abused or neglected, they don't need a guardian because their funds are being managed by the provider. They have the supports and services that are in place to help them make those decisions. So now I want to talk about the different types of guardianship. So a temporary guardian is what the court will put in place when someone first goes into court and oftentimes there's a medical emergency. So a guardian needs to be put in place right away because oftentimes they have, you know, a health condition and they're not able to make their medical decisions. So that is normally just right at the beginning of the case and lasts for 60 days while the court investigates the circumstances and determines if it's really necessary for a full guardian to be put in place. So then there are two different categories, kind of like we talked about with powers of attorney. There's a guardian of the person, which is over personal decisions, healthcare decisions, residential decisions. And then there's a guardian of the estate, which is over finances, contracts, and things of that nature. And in both of these categories, the court can appoint either a limited guardian, which is not a full guardian, which is where the court specifies that, you know, this person has some abilities. They're actually not totally incapable of making their decisions, but there might be some area where they need help. And the court will specify what that area is. So, for instance, you know, with healthcare, if the individual has a particular health decision or health condition that they're, having problems managing. They might appoint them for that, or, and they need help finding doctors and treatments for that. For a guardian of the estate, if an individual, has, might be involved in some lawsuit and need help managing that lawsuit, or might have come into some funds, or have like one bank account that they need help managing. So the court will be very specific about that. A plenary guardian is the full guardian, is what we know as a full guardianship. So where the individual has all the rights and powers of a guardian. So you will specify that in your pleadings to the court, and that is also part of your discussion with the healthcare provider. Often, some counties have specific forms for a doctor to fill out to support the petition. Some don't, but oftentimes they also ask for the doctor's recommendation whether they think the individual has, is fully incapable of making their decisions, or just partially incapable. And so that's what kind of leads also to the limited versus plenary is the doctor's recommendation. But yes, in the pleadings in your petitions to the court, you want to specify, why you think the individual needs a guardian and what they need help with. So therefore, what authority. Okay, now I'm going to talk a little bit about the guardianship process. So, this is a process that must be followed correctly in order for the guardianship to be put in place. I can't advise you on whether you have to have an attorney for this or not. I mean, in general, like I said, the courts do have forms. It can be pro se, but it is also litigation. So that it is a court process. So it does need to be carefully followed, and attorneys do handle these cases. So who can file a petition for guardianship? Either an individual or an organization. Hospitals file for guardianship over individuals in the hospital. Some agencies file for guardianship. So in determining who can act as guardian, an individual can act as a guardian who is at least 18 years of age, has not themselves been adjudicated to be disabled and need a guardian, and if they have not been convicted of a felony. If they have, the court does look into it a little carefully to see if it would be in the best interest still for that individual to become the guardian. Also, a public agency that the court finds capable of being a guardian can become a guardian. So just one thing to keep in mind is an agency that is providing care for the individual cannot become a guardian. So like a SILA provider or a day program provider, or like a social worker who might be part of those organizations, or things who are providing healthcare services or residential services directly to the ward cannot become the individual's guardian. In Illinois, the office of the state guardian is the guardian of last resort. So for individuals who don't have any other family member or friends and don't have any other assets. And then for individuals who do have some amount of assets, in each county there is a public guardian that serves as guardian if there's no other family or friends that are able to serve as guardian. I'm not going to take you, each case is a little different, and I'm not going to take you step by step through the whole process, but when I just want to notify you of a few things. When you file in court, you'll be, given a court date, and oftentimes the judge will appoint someone called a guardian ad litem, who is oftentimes an attorney in that area, who will look into the claims that you've made in the petition, and they represent what is in the individual with a disability's best interest. So they are supposed to go and meet with the individual, explain to them what the petition says, explain that what guardianship is, what's going to happen, and see what they feel about it. Inform them of what their rights are in the process, and then likely talk to the doctor or review the medical report, and then make a recommendation to the court. So I just want to let you know that that is an individual who's involved.
But that's not required.
It's up to the court. They make. Well, yeah, I mean, it's up to the court whether they appoint someone to do that or not. And so these are the rights of the individual with a disability, who we also refer to as a respondent once the case is filed. And this is what the guardian ad litem, if they are appointed, will be informing the individual of, or the individual will receive will receive a notice of these rights with the petition. So they have a right to object, basically, to having a guardian appointed for them. They can ask to be appointed a lawyer to represent them. They can be present at the court hearing. And so the other thing is kind of getting to your question. They have the right to ask the court to appoint an independent expert to examine them and determine and to give their opinion on whether they think they need a guardian or not. So generally, when you file a petition, you're required to have medical support for the need for a guardian. And so the court generally does not automatically appoint an independent expert to, go out and examine the individual. But if the individual asks for one, then the court will appoint one. If an individual with disability wants to designate someone else as their power of attorney, yeah, that's fine. I often recommend if they're in a situation where they think that down the line there might be someone who is going to challenge that power of attorney, to say that at the time you created this power of attorney, you were not of sound mind, you did not have the capacity to create that power of attorney. I recommend that they go see their doctor around the time that they create that power of attorney, to have documentation for the doctor to confirm that they did have sound mind to create that power of attorney. They were able to do that at that time. But anyone can decide to create a power of attorney at any time that would be to help them right now or in the future. I know that there are links on the Guardianship and Advocacy, I think, on their website. They have power of attorney forms, as well as if you go on Illinois Legal Aid online, they have power of attorney forms as well. And those are like the standard forms with the standard language that the Illinois law basically requires. The Illinois law has a standard language, and those forms mirror that language. If the judge wants to see them, or if they bring a problem to the court, or if someone else brings a problem to the court, they never have to be. I would say it's up to them, and it depends on the issue. You know, if they're unable to come to court, but they would like to come to court, they would like to object, that is another one of the reasons why the court would appoint a guardian ad litem to go and meet with the individual and then report back to the court. You know, like if they were objecting and wanted to be represented by a lawyer, that's what the guardian ad litem would communicate to the court. Then the court would appoint them an attorney who would work with them and advocate on their behalf in the court process. Illinois Legal Aid Online, that is a great resource on really all areas of the law. They have a lot of, they walk you through completing some forms. They just have a lot of, you know, basic information on different areas of the law, and they also connect you to different legal aid providers over the whole state. Yeah, you're welcome. Illinois Legal Aid Online. Okay, just a few other rights. They also have the right to ask that the hearing be closed to the public so that there are no other individuals or cases in court at the time. Sometimes courtrooms are very busy places, and there's a lot of other cases and people in the courtroom, and you know, these cases are really dealing with an individual's very personal information, their healthcare information, their capabilities, their abilities. Sometimes, you know, they're talking about how individuals have been mistreated. So the Illinois law recognizes that individuals have a right to privacy in these proceedings. You know, the law also recommends that, you know, if it is appropriate for an individual to have a limited guardianship, that should be favored over just appointing a full or a plenary guardian. The effect of a plenary guardian is that it could limit an individual's right to marry. It also, with a plenary guardian, the Secretary of State is not supposed to issue a driver's license to that individual, because a plenary guardianship, the court is finding that that individual is disabled under the guardianship law. So it's finding that they are totally incapable of making responsible decisions. And so that is a finding of disability for the purposes of guardianship. So those are some effects of having a plenary guardian. There is a process to still get married, but they should not be allowed to still get a driver's license if they have a plenary guardian. There is a process under the guardianship, the Probate Act, which is the guardianship law, where if they have a plenary guardian, the guardian or the individual can petition the court basically for permission to get married, and they have to demonstrate that they understand what marriage is. Okay, so now we're going to skip ahead to you know, when a guardian is in place. And first we're going to talk about a guardian of the person. So if a guardian of the person is in place, they have the duty to take custody of the ward, and if the ward has any minor children or adult-dependent children. They also have the duty to try to maximize the individual's independence and self-reliance. We think of, this as living in the least restrictive environment as possible, helping them to develop skills, maybe helping them to work. In addition, the guardian of the person, the court will order the guardian of the person to make reports to the court. Every court is different. Some courts order them to report back every year. Sometimes it's every 3 years. It just depends on the court. So if you have a guardian of the person, how are you supposed to make decisions on the individual's behalf? So the Probate Act says that the guardian must try to make decisions that are that the individual wants. So they have to try to determine, what it is that the individual wishes. And if the individual is able to say exactly what it is they want in a particular situation, the guardian should follow that, unless they're concerned that that decision would cause them harm. Okay, if the individual is not able to expressly say what it is they want, then the guardian should try to figure out what the individual would have done, so under the circumstances. So if this is a decision, if the individual had a health condition that came up suddenly, okay, and they didn't always have that condition, in that case, maybe the individual would look at, what did they do in the past if this situation arose? They should also take into account, how the individual has acted in the past, what their family beliefs are, what their religious beliefs, things like that. So then if that is unable to lead to any clear choice of what the guardian should do, then a guardian makes a decision that is in the ward's best interest, okay? And they do that by looking at, the reason for what is being done, the benefit or the necessity of it, and the risk or consequences, and again, taking into account what the community around this individual, might have advised the individual. So that's the standard kind of for talking about all decisions. And now I'm just going to talk about a few particular situations regarding the guardian of the person. So the first one is where is the individual going to live? So the court order will, when appointing a guardian, will say specifically for a guardian of the person whether that guardian has the ability to determine where the individual is going to live or not. The Office of the State Guardian and the Office of Public Guardian, they automatically have that right, but when an individual is appointed, the court has to specify. Sometimes they might specify, okay, this individual, the guardian has the ability to make that choice, but the court wants to review it first to approve it. So that can happen as well. So similarly to the process of decision making, which I just talked about, when determining where an individual is going to live, the guardian has to talk to them and find out, where, do they expressly say where they want to live? If they can't say that, whether, whether determining on the circumstances, where they might want to live, and if neither of those are true, then they are apparent, then they make a decision that's in the individual's best interest. So again, if an individual expresses something that they want to live somewhere that the guardian suspects is not the right choice, is going to put them in harm, then it's the guardian's responsibility to make a decision that is not what the ward wants. But in making this determination, the ward has the right to live in the most independent placement as possible. And a guardian really has the duty to monitor where they live to make sure it always continues to be the right place. Because what might be the most appropriate place at one point in time might not be the same place that's appropriate for them 5 years down the line or 10 or 15 years down the line. Okay, so one note here is that if an individual with a guardian has a mental illness, a guardian cannot admit them into a psychiatric hospital over the individual's objection. So in that case, the guardian has to file a case in the mental health court to get the approval of the court to involuntarily admit the person into the psych ward. So similarly, talking about healthcare decisions, we're running a little bit out of time, so I'm going to move through this a little bit quickly. But a ward still needs to be consulted as well when making healthcare decisions. These are some exceptions where there are specific rules for. So similarly, what I just talked about with regard to admission into a psychiatric hospital, a guardian cannot force an individual cannot force an individual to take psychotropic medications or to receive electroconvulsive therapy if they are objecting to it. So again, you would have to file a petition under the Illinois Mental Health and Developmental Disabilities Code to get the court's permission to have a hospital or doctor administer these treatments over the individual's objection. If sterilization becomes an issue, there is a specific process that the probate court requires in order for this to occur. An individual must be awarded due process because individuals have the constitutional right to make family and reproductive decisions. So in order to sterilize the ward, even if the individual seems to consent to it, a guardian has to go into court to receive the court's approval. And the court will look into this matter and determine whether it's appropriate or not. Even if an individual has a guardian, they still have a right to their health care information. So they can still have access to their own medical records. But a guardian of the person does have access to an individual's mental health records, including powers of attorney. Also have access to those records. Okay, so now we're going to talk about guardian of the estate. So like we talked about, this is the guardian over financial issues, over contracts. These are some of the duties of the guardian of the estate. Similar to with a guardian of the person, a guardian of the estate has to periodically, it should be every year, to the court about an individual's finances and how the money is being spent. Oftentimes, too, if the individual does have significant assets, the court will also set up and approve a budget for the individual. Similar, I get with a guardian of the estate, similar to a guardian of the person with decision making, you know, the guardian must make decisions, you know, that the ward wants, you know, unless it would cause significant harm. But, you know, the law specifically says that the ward's wishes, you know, must be carried out whether or not tax savings are involved. And that the guardian can give the ward money directly from their own estate. Similar to some of those healthcare decisions, there are specific areas where the guardian of the estate still has to go to court to get permission, okay? So a guardian can't sell real estate or purchase real estate without a court order, or personal property. And really, you know, the court is concerned of any self-dealing there, where the guardian, you know, might be purchasing things actually for their own benefit. So the guardianship court, you know, really has a duty to look over carefully of the ward's finances. Oh, sorry, I skipped over that. So under a plenary guardian of the estate, the ward does lose the ability to enter into contracts. So enter into a lease, enter into, you know, a mortgage. You know, oftentimes we see more, this becomes an issue with a lease for an apartment or things like that. And contracts entered into by an innocent third party, so a third party that doesn't know that the individual has a guardian, are voidable by the guardian, but not by the innocent party, so not by the party. It's hard. You can't really put guardianship in place in the future. You know, guardianship is determined about what the individual's capabilities are right at that moment in time, and what the individual's needs are at that moment in time. I would like to think that I think it's very, you know, we advise parents to, you know, prepare for that inevitability when they are no longer around, especially with placement issues, with, you know, being placed in a CILA or, you know, some sort of community setting. And so I think we would like to think as well that, you know, if those individuals are receiving, you know, services and are receiving the support that they need in those areas, that you know, by the time you know it arises to that point, they have the capability to make those decisions, and they have those supports and services in place, so they might not need a guardian. But I know that's not always the case. But guardianship is determined at that moment in time. So just to keep that in mind. Really quickly, once a guardian is put in place, it doesn't mean that it's in place or it's going to be that way forever, okay? So an individual can go into court and say, for instance, that a particular guardian is no longer the right person or the right agency to fulfill that role. They're not doing something properly. They're mismanaging funds. They're not making the decisions in the way that the individual would like or in their best interest. And so anyone, or they don't need a guardian anymore. So that's one of the services that Equip for Equality provides. We help people to terminate a guardianship when they don't need one anymore. And so in either of these instances, someone can notify the court either through writing a letter to the court to inform them if there's a problem or if the individual no longer needs a guardian, or to write a formal, what we call pleading or petition to the court, asking them what to do. A guardian can be removed if they are not performing their duties in the way they should be. We often see this when money is being mismanaged, when they're using the ward's funds actually for themselves, or they're not listening to the person about where they want to live, if they're trying to put them in a facility that is more restrictive than what the individual actually needs. So if a petition like this is filed, the court will require the guardian to respond to it and will investigate those allegations to determine whether they should be removed or not. Lastly, we do see that people have had like a co-guardian appointed, maybe when a parent or a family member is getting older and they think that they can't manage all the responsibilities alone, and they want to set up someone else in place to manage them when they're not able to do so anymore. So that can happen, or sometimes in pleadings, the court will ask a guardian to kind of designate, okay, when I'm no longer around, if I'm no longer able to do this, who else should be appointed as a successor, the next person. But no one, if the guardian is no longer able to do so, no one automatically is replaced as the guardian. The court has to be notified about that and has to appoint someone else. These cases are in the individual county presumably where the individual lives. So if an individual moves to a different county and really has no other connection with the county where the guardianship case is, the case should really be transferred to the county where the guardian, where the individual is living. So there is a process where you notify the court of where the case is, and then they will transfer the case to the other county. Similarly, if the individual moves out of state, there is a process. You can't have two guardianship cases in different states, okay? So there is a process for transferring, that case from Illinois to the other state. And, that is a move that the court should approve. The guardianship court needs to approve in the first place. So the guardianship court needs to approve that it's okay for that individual to move to another state. If you have a guardian of the person who is in charge of making those residential decisions. And as I understand, if individuals are in a facility, like a nursing home or a mental health facility or a facility for people with developmental disabilities, I think there's like one counting day when a census worker will contact the place and then get that count on that one day. I think that's how it works. Well, thank you very much for having me.